Bang, it was many years ago. Sarah, thank you for that very, very kind, generous introduction. It brought a big smile to my face. I was the recipient of an award some time ago, and after the ceremony, our very young, precocious granddaughter came up to me and hugged me and gave me a kiss on the cheek and whispered in my ear, "So why don't you have a television show?" I told her I'm still working on it. But thank you so much. It's great to be here. This is a very special event. It's been a long day, but it's really a pleasure to be here this evening to welcome Hannah Lieberman on her appointment as Executive Director of the Neighborhood Legal Service Program. Upon my graduation from the Howard University School of Law in 1971, I was the recipient of a fellowship, as Sarah indicated, from the Reginald Heber Smith Community Lawyer Fellowship Program. Reginald Heber Smith was the architect, as we understand, of the concept of providing legal services to people who could not afford to pay for those services. The fellowship recipients were affectionately called Reggies, and we were assigned to various legal services programs throughout the country. Because I am a native Washingtonian and proud of that, I was assigned to work with the Neighborhood Legal Services Program in D.C. Those were exciting times because the United States Court of Appeals for the District of Columbia Circuit, and I saw Pat Wald here earlier, I didn't get a chance to speak to her, but that court had recently decided a number of important cases that established what has become known over the years as a D.C. tradition of cutting-edge landlord and tenant law decisions recognizing the rights of tenants. Those decisions, Brown versus Southall Realty Company, Javins versus First National Realty Company, Bell versus Centolis Realty, and many other decisions issued by the Circuit Court and later the D.C. Court of Appeals, have been followed and applied by courts around the country. I could not have been a Reggie at a better time because I had the privilege, pleasure, and opportunity to continue my legal education and to learn from some truly outstanding lawyers like Sarah Reardon, Willie Cook, Dalton Howard. I saw Mike DeMoy here, Susan Shapiro, Ellen Scully, Tony Kramer, and many other dedicated, brilliant, underpaid lawyers fighting for justice for people whose legal rights had gone unrecognized and unprotected for years. What a wonderful way to start a legal career. I'm frequently asked about the cases I presided over that are the most memorable, and that's indeed a difficult question because I have presided over hundreds of cases on the three courts I've had the privilege and honor of serving. The Ted Stevens case will always be one of the most memorable, but another case that ranks near the top of that list was actually a small claims case with landlord-tenant overtones that I presided over shortly after my appointment to the Superior Court. The case was filed by public interest pro bono attorneys, and they represented a woman whose name was Robin GB. Ms. GB had sued her landlord for damages, alleging the landlord's breach of an agreement to rent an apartment to her in habitable condition. The argument was compelling. The landlord, a high-ranking federal government official, had received a security deposit and first month's rent from the plaintiff, an expectant mother of two, whose only wish was to move from her very small apartment before the birth of her third child. When she moved into the new apartment, however, she found burst water pipes. The refrigerator did not work at all. The apartment was littered with trash. The walls were moldy. The locks were broken. There were no handles on the faucets. And worse, her telephone calls to the landlord about the promises he had made to make the repairs were not returned. The plaintiff sued for her security deposit and first month's rent, but there was a twist. She also requested an award of punitive damages, and this was a small claims case. Then, awards of punitive damages were virtually unheard of for breach of contract matters at that time and never heard of in small claims court. So I did what new judges do sometimes. I took the case under advisement and for some time and wrestled with the issues for some time. not certain about what to do or how to do it. Then one evening, I went to the Howard University School of Law, the moot courtroom, because the word was out in the community that Justice Thurgood Marshall was to speak that evening. That was a really rare event because Justice Marshall rarely spoke publicly. He talked about his career and about how important it was to use the law as a tool to find ways to right wrongs. And he was quite passionate and emotional about his job, and he had this very powerful, charismatic presence. I recall him saying that you just have to find a way to reach a just result, and more often than not, it will not be easy. You have to find a way. I thought he was talking to me. I left that courtroom that night refocused on the case under advisement, determined and committed to try and find a way to arrive at a just result. The case was very compelling. The facts were extremely shocking. The relief was unprecedented. I arrived at court the next day and told my law clerk, my first law clerk, that we needed to do some more work. We did, and we found the very few cases in the country that sanctioned an award of punitive damages for a breach of contract claim, but only if the breach of contract rose to the level of a tort. Now, in my view, the tort in this case was fraud on the part of the landlord in accepting the rent and security deposit with no intention whatsoever to make the repairs and put the apartment in a habitable condition. I also concluded that if I was going to be so bold as to award punitive damages in a small claims court proceeding, then I should put pen to paper and issue a written opinion. Now, writing opinions was not something I'd planned to do as a brand new judge. I hadn't planned to do that for quite some time. But I thought I might enhance the opportunity to withstand the appellate scrutiny that was certain, in my mind, to follow. I did award punitive damages to the plaintiff in a written opinion and moved on to the next case, uncertain what would happen with the award of damages, but confident that I thought I was correct. I'll never forget that it was a Saturday morning shortly after the opinion was issued when I started reading the Washington Post and came across an article with the bolded caption, "Court awards tenant punitive damages for defects in apartment." Now, you could have knocked me over with a feather. The article went on to say that the judge had made local history and that the decision could be the start of a trend in the city, if not the country, in making landlords strictly liable for the condition of their property. All I could think of at that point was that Justice Marshall made me do that, and that I would probably get summarily reversed. I knew in my heart that D.C. Court of Appeals was meeting in a special session that weekend to reverse me. But when I got to the end of the lengthy article, it concluded by acknowledging that the landlord had agreed to pay the compensatory and punitive damages to the plaintiff. The feeling of satisfaction and fulfillment on my part was simply overwhelming because I knew at that point that I had administered justice as a new judge and had made a positive difference in the life of someone. I'm so fortunate to have had that experience early on in my judicial career and the experiences as a Reggie at the Neighborhood Legal Service Program, because those experiences and others in my life set the tone for my sense of justice that I have endeavored to administer over the past 28 years. The sad truth of the matter, however, is that there are scores of Robin Jeebies in this community. There are scores of Robin Jeebies who lack the financial resources to pay for brilliant lawyers, to advocate on their behalf, and to obtain the justice that they're so entitled to. Thus, we are extremely fortunate to have the dedicated, brilliant, conscientious Neighborhood Legal Service Program attorneys representing indigent residents in the District of Columbia. Hannah Lieberman, I salute you on your appointment as the next director of the Neighborhood Legal Service Program. You have a challenging, golden opportunity to provide leadership to dedicated and brilliant attorneys in their quest for justice for their clients and to indeed make a positive difference in the lives of many. You will unfortunately have to deal with the bitter realities of slashed funding, but that should motivate you even more so to intensify the fight for justice that your clients not only demand, but are entitled to. And I salute you. Thank you.